In re Devore Stop, Stephen Wade appearing for appellant, Kara Hagan appearing for appellee.
All right. And Mr. Wade, do you wish to reserve time for argument? For rebuttal, excuse me.
I do, Your Honor. I'd like to reserve 5 minutes.
Okay, thank you very much. You may commence.
This case is a case which normally I have tried the case by the time I bring it to this court on appeal. And I've lived the case. This is a case that came to me after the order had been entered to handle the appeal. And I've struggled mightily with both the complexity and at the same time the simplicity of the decision in this case. Complexity in that the terms arising in, arising under, and related to have been used widely by the courts, and in some cases broadly, in some cases less broad, and trying to understand and differentiate whether a case arises in, arises under, or is related to, I find to be one of the most difficult areas of law. However, in this case, I believe that the simplicity of this case arises out of the clear and unambiguous language of the 2007 sale order, wherein Judge Noggle in that decision specifically retained jurisdiction in the sale of the property, not only a generalized statement to determine in a subsequent action or actions the nature, extent, and validity of any lien or encumbrance on the property, but with specific reference to Mr. Morshauser's rights as the purchaser at that time to have an action, to maintain an action to determine the amounts that were owed and the liens and the amounts thereof that were contained on the property that he was purchasing.
Well, isn't there a difference between a judge saying, I will retain jurisdiction to do something, and later looking at the question and determining that, in fact, it does not arise under, it does not arise in, and it is not related to because of the nature of the dispute? I mean, aren't those two different questions? And isn't the important one whether you can find jurisdiction under the doctrines that we all understand to be pertinent here?
Well, I think the Court of Appeals, the Supreme Court addressed that exact issue in the Travelers case, wherein it first addressed the issue of whether or not the predicate order was within the court's rights to issue that order. In other words, did the court have jurisdiction to issue that order originally? And in that case, it found that the bankruptcy's order was final and non-appealable. And as a result, it met that predicate jurisdictional issue. I don't think there's any question that a court, when they're issuing a sale order, has the inherent jurisdiction within that sale order to retain jurisdiction to enforce the terms of that sale order.
Well, sure, but there's an awful lot of decisional law in the Ninth Circuit, arguing out the Supreme Court, that talks about, after the fact determinations of jurisdiction, and indicates to us that we have to look beyond just whether the court says it could have done something. I mean, I know that this is not a Chapter 11 case, but even in the Chapter 11 situation where the court goes to the extraordinary length of confirming a plan, which didn't happen here, by the way, that, even then, the appellate courts tell us that we have to be very careful about exercises of jurisdiction, and it's not enough that the court said, well, yeah, I may decide this in the future. That just isn't the answer.
Your Honor, I think that's the beginning to the answer. And the court in the Travelers case went further after it determined that the predicate jurisdiction had been determined. Then it indicates that the only question left is whether the bankruptcy court had subject matter jurisdiction to then enter an order either enforcing or clarifying that.
Let me just cut to the chase on this one. Are you going to tell us that this is arising under jurisdiction? You're not, right? Your
Honor, I believe that it can be it can be determined, as I've argued in the brief. It can be either, some of the cases have held that it's arising under, some have held that it's
No, stop. Let's not waste any more time. Arising under means that the rule of decision is supplied by the bankruptcy code. How is that possibly the case here? These are state law issues. There is no bankruptcy code section that determines these issues, is there?
No, Your Honor, but I don't think that that's under the Franklin case. The court indicated that it was both interpretation of its order and enforcement of its own order.
That's a different question. That's simply a different question. What I'm trying to figure out is there really a basis here to determine that this was arising under? You're going to have a very hard time convincing me of that. I understand the argument about arising in, and I guess I will ask you if you're going to tell us that there is independent arising in or related to jurisdiction here, putting aside the fact that the court said, I may decide this at some future point.
That it retained jurisdiction if it was brought before the court. Your Honor, I think that the related to jurisdiction, and I've cited a number of cases which rely on the related to jurisdiction in a line of cases that goes back both within the Ninth Circuit and then ending up in the Traveler's decision, where it found that the court's inherent jurisdiction to enforce and interpret its own orders established the related to jurisdiction. In that case, it relied on the decision in Ray Taylor in the Ninth Circuit, and subsequently it was reinforced by the Ninth Circuit in the Wilshire case.
Okay, let me just stop you. Related to ordinarily means that it could have some effect on the debtor or the estate, or claims that are held by the debtor or the estate, correct?
I don't believe it's limited to that.
Okay, what else do you think it would be?
Limits that.
What else would it be?
Your Honor, I think that the courts, again, the decisions in Bailey, in Franklin, in Wilshire, and then in Metzger in front of the bankruptcy appellate panel all say that the retention of jurisdiction to enforce and interpret the court's own orders is part of the related to jurisdiction.
Well, wouldn't it also be the case that what you're really arguing about here is a whole bunch of stuff you never told the bankruptcy court about?
I don't believe so, Your Honor. These cases were all the Franklin case was the primary case.
No. I'm talking about this case. Actually, what really happened here, and Judge Houle having to tease out. And I know you weren't counsel at the time, so this is no finger pointing at you. But Judge Houle's decision makes clear that it took him hearing after hearing after hearing, year after year after year, to figure out what really happened here. Because the parties who, the people you want to fight with here, there were side deals that the court never approved. Isn't that a problem?
Your Honor, I don't think it relates to the court's jurisdiction. I think the court addressed that issue. And it sanctioned all parties that were involved in that. So I think the court addressed that the concerns that it had there. I can't say whether or not that determination spilled over into the court's determination to withdraw the jurisdiction in the motion that I'm appealing. I can't say. All I can do is address whether or not the court had jurisdiction, and I believe it believed that it did.
Yeah, the argument would be it's not interpreting the court's prior order when the parties went on and made a whole bunch of other agreements that are not reflected in that order. That would be the argument, and I think that's what Judge Houle was a little hung up on.
There's no doubt that the impact of the court's sanctions determination against all parties colored this court's decision. However, I don't think it changes the legal basis for jurisdiction. As I indicated, this court determined that there was jurisdiction.
Mr. Wade, breathe. Can I ask you a slightly different question based on what Judge Lafferty is talking about, which is, what was the judge interpreting in terms of the order? I mean, what was the ambiguity that the judge was plumbing the depths of here? I just don't see interpretation of an order at all.
Your Honor, that's why in my brief I went to the issue of enforcement, and interpretation and enforcement go hand in hand in all of the decisions.
Well, what
No, I
is
believe that the order is
enforcement
clear and
of
unambiguous.
the order? You know, there's the order gave the judge an option at some unspecified point to do something. What is the enforcement piece?
The enforcement is, as the language of the order says, to determine the nature and extent of the liens that were on the property that Mr. Morshauser purchased from the bankruptcy estate. His complaint seeks to do exactly that.
That is simply not
the nature and extent.
That is simply not
claim.
Enforcement. That just isn't enforcement. That's plumbing into an issue as to which the estate is indifferent.
Whether or not
why is it anything other than that?
If the state had a direct interest in this, it would provide an additional basis for determination and jurisdiction. But neither the dismissal of the underlying case, as I've indicated in my brief, does not act to determine that, nor is it limited, the enforcement limited only to the estate. It's the estate, in this case, it's the purchaser of the property. The purchaser has a right
what was sold
to
was
rely
as
on that
is.
order.
What was sold is as is, where is, right? I mean, that was the whole point. We aren't going to figure out the liens here. Isn't that right? We don't know what they are.
Correct, Your Honor. As is, where
subject
is
to.
applied to the condition
It was subject
of the
to.
property.
But there was no determination, right? One way or the other. And the estate is indifferent to that, isn't it?
The estate may be indifferent to it, but the buyer is not.
But
The
you're
buyer
not
of the
you're not
property has a
arguing. You're not
right to
arguing,
rely on that.
Mr. Wade. There's no
Yes.
dispute that there was a lien there, right?
Correct.
And now you are arguing subsequent events have established whether or not that's enforceable. That's the problem here, is you are asking down the road, water under the bridge, for something that happened to adjudicate the validity, the existence of the lien and the validity, the payment of it. But that doesn't go to the lien that existed, which was sold subject to. That's why it's not enforcement. Isn't that right?
Your Honor, it was sold subject to liens. However, those and it was sold subject to that lien, and we understand it was sold subject to that lien. However, the court, in order to provide the incentive for Mr. Morshauser to purchase this, reserved the issue of the nature and extent.
But that can't confer jurisdiction, as
liens.
Judge Lafferty has indicated several times, over that which does not affect the estate.
Your Honor, it does affect the estate.
No, I don't think it does,
absent-
because the lien's there. Nobody's disputing that the lien's there. Now you want to argue what happened afterwards, whether or not between the parties that are issued that are not the estate, whether it was satisfied or not.
I'm
Your
going
Honor,
to suggest
if I
that
could be-
Mr. Wade reserve his 2 minutes and think about answering that question.
Thank you, Your Honor.
Okay. Sorry, unless my colleagues disagree.
No, I don't.
Okay, thank you. All right, then let's hear from Ms. Hagan.
Good morning, Sarah Hagan on behalf of the appellee. Your Honors are all exactly right in saying pretty much everything that I would have reiterated, so I don't want to waste the court's time. But I think that the three primary places that this is distinguishable from everything that Mr. Wade has suggested is we're dealing with non-debtor parties. The debtor in this case is Devore Stop. Mr. Morshauser is seeking to enforce, interpret, do whatever he wants to do with parties that have nothing to do with the debtor in this case. Two, it's years after the case has been closed. And so almost all of the cases that Mr. Wade has cited have an ongoing pending case proceeding. We challenged throughout this litigation that every time Mr. Morshauser raised one of these concerns, that there were a myriad of options where he could have gone back to Judge Noggle and asked for clarification or got something corrected or did whatever needed to be done, and he chose not to do that, waited for buying up the remainder of the assets in 2007, and then hanging around till 2012 before even addressing the adversary issue.
Can I ask you a question? This may not be directly relevant, but there was a state court action brought, right?
Yeah.
Was it the mirror of this, or was it something else?
No, it was not. It was fraud.
Okay, it was a different cause of action. Okay, so that's not preclusive one way or the other. If Mr. Morehouse, if there were a claim to be brought in state court, you're not saying he's precluded from bringing it.
Not unless there's some other state court for it.
Okay.
And that up on appeal. The rulings in that particular state court case went up to the more confirmed. But you're exactly right. It's a state court issue. I mean, the causes of action as pled, quiet title is nothing more than a state court issue. Judge Poole was very, very clear, and I thought did an excellent and very thorough job at analyzing core, non-core, retained to explain why he did not believe that it was appropriate. And I just don't think having a 2007 sale order, even though it references Mr. Morchauser's name, it certainly doesn't address what claims. And the claims that he so-called or once enforced or interpreted deal with non-parties to non-debtor parties. And I certainly don't think this order had any intention of including anybody that Mr. Morchauser may want to have claims against. He all of a sudden gets to have those decided in the bankruptcy court.
Let me ask you this. If this had been timely in a different way, if this action had been filed before the case were dismissed, do you agree with Mr. Morchauser that somehow, even as between third parties, this could have or should have been determined by the bankruptcy court?
No, I don't.
Okay.
I think the other two prongs of the test would then apply. It's still, this is a general sale order for the remainder of assets after, I mean, the bankruptcy, frankly, was almost concluded in 2004. So it was just his cleanup, so to speak. And it's super interesting because it's Mr. Morchauser who's buying up these additional assets. Mr. Morchauser is one of the parties to the original notes, the 850 note and the 150 note, but the debtor is a different party. So it is just super convoluted as far as, you know, how he's weaving himself in and out. I'm the debtor here. I'm not the debtor here. I'm the creditor. No. I'm a wronged party. You know, it just isn't appropriate. And I think Judge Poole was really clear in making sure that everyone on the case knew that, especially through that OSC procedure. If Your Honors have any other questions for me, otherwise I think we've addressed what our general position is.
All right. Anyone have any questions? Judge Spraker?
No, thank you.
Judge Lafferty, anything further?
No, thank you.
All right. Okay. Thank you for your good argument. All right. Let's hear again from Mr. Wade. Mr. Wade, you've got right under 2 minutes. Mr. Wade?
I'm sorry, I was muted.
Okay, good. I was afraid we'd lost you. All right, go ahead.
Judge Poole, in his order entered July 25th, 2013, made a finding in this case that the court's ruling in that matter found that this court has proper jurisdiction over the issues raised to the extent they request to determine the effect of a prior order of the bankruptcy court. And further, that here, pursuant to the Morchauser sale order, that's the 2007 order, the court retained jurisdiction. So this court made the determination that, in fact, it had jurisdiction to hear the complaint that was filed in this case, pursuant to the terms of the 2007 order. Subsequently, the court indicated no, it did not have jurisdiction. The only things that happened in between are, first of all, the sanctions issue, the order to show cause, which I argue does not change whether or not it originally had jurisdiction, and then the determination of an issue regarding employment of a broker, which the court said, well, now that we've determined that there was a broker was properly employed, that removes the jurisdiction. I don't believe that either of those are consistent or consistent with the courts related to jurisdiction to enforce its own orders. This court made that determination, and it made it in favor of our position. And nothing changed except the order to show cause, which undoubtedly changed the court's flavor and attitude towards all parties to this case, including my client. And the court, in essence, wanted to wash its hands of the case. But I don't believe that the court could do that based upon a finding of a lack of jurisdiction.
All right. Well, thank you very much for your good arguments. This matter will be under submission, and we will be adjourned at this point. Thank you again to both counsel.
Thank you, Your Honors.